Hi, thank you all for joining us today for our presentation on the National Interest Waiver. My name is Dustin Saldarriaga, and I am a Senior Associate at Scott Legal PC here in New York City. We are very fortunate today to have my colleague Jiyae Hwang presenting for you all on the National Interest Waiver. Jiyae has prepared a number of these applications and has extensive expertise doing so and helping clients navigate through the process. Before we get started, a few items to share with you all. The first is that we do try to do about 2 webinars a week, and these cover a variety of immigration topics. Although our firm does focus on business immigration, we handle the full spectrum of U.S. immigration law, whether that's temporary visitor visas, student visas, or green card options for family-based applications or employment-based applications, like what we'll talk about today. Excuse me. After the presentation, you will receive an email with a link where you can sign up for our future webinars, and we hope to see you on those presentations. We also will share with you the presentation that you see on your screen, as well as a link to our YouTube channel. This presentation is being recorded, and we do post our full-length webinars on our YouTube channel, as well as other shorter videos. And again, those do run the full spectrum of U.S. immigration. We try to cover a wide variety of topics, and we hope you find those helpful. If you would like to schedule a consultation with us to talk about the specifics of your circumstances, we would be very happy to talk with you. Please visit our website. And again, that link will be in that email you get. You can schedule either a 30-minute or a 1-hour consultation at a time that works for you. It's a very straightforward process and really would give us a chance to learn about the specifics of your goals and your circumstances and would help us help you navigate them in a more specific, nuanced way than we can on a webinar. But on this webinar, if you have a question that relates to the presentation, do send those in either through the chat function or the Q&A box. I will be monitoring those. We do plan to get through all the questions by the end of the presentation. We will likely save the questions for the end, but we do plan to get through all of them, so don't hesitate to send in your questions. Without further ado, I'm going to pass it off to Jiyae.
All right, thank you so much, Dustin, and thanks everyone for joining us today. So let's talk a little bit about the basics of a national interest waiver and go through the requirements to qualify. So as many of you may know, the national interest waiver, the NIW, is a subset of the EB-2 employment-based immigrant petition. And immigrant petition means that this is an application for a green card, U.S. permanent resident status. And, a green card is something that gives someone the ability to live permanently in the United States and work for any employer or not at all. And having the green card will also open up the pathway to U.S. citizenship in the future. So the EB-2 NIW is a popular choice among individuals who want to apply for a green card on their own, and this is called self-petitioning. And if you qualify for the EB-2 NIW, you can apply for the green card as an individual, whereas normally you would need a US company to sponsor you for a green card. The EB-1A Extraordinary Ability Green Card is another category that allows self-petitioning, but the EB-1A typically is really reserved for, the individuals who have reached the very, very top of their fields, the top 1%. So the EB-2 NIW may be a more viable option for a more wider variety of professionals who can nevertheless show that their work will make significant contributions to the industry or U.S. society. So let's go through the eligibility criteria in a little bit more detail. So what are the eligibility criteria for an NIW? So the first and important thing to note is that both for EB-2, regular employer sponsor petitions and for EB-2 NIWs, you do need to make sure that you first meet the EB-2 threshold. And you can meet the EB-2 threshold by 2 ways, either by showing that you have an advanced degree, and I'll dig a little bit deeper into that, or by showing that you have exceptional ability in your field. Now, let's talk first about the advanced degree. So an advanced degree is defined as a master's degree or higher. So this includes degrees like, an MBA, for example, in your field, or a JD or MD even, degrees that require typically for someone to have a bachelor's degree before gaining admission to that type of program. So that is also considered an advanced degree. Now, if you don't have a master's degree or a higher degree, you can also qualify as an advanced degree professional by showing that you have a bachelor's degree in your field and 5 or more years of progressive work experience in your field after you obtained your bachelor's degree. And progressive work experience means that basically your job duties did not stay the same over the 5 years that you've worked, but they progressively improved in seniority and complexity in the job duties that you performed and the responsibilities that you had. So you can show this by getting a letter from your previous employers showing that your title has changed, for example, from junior associate to senior associate, for example, or your salary has changed upwards, or generally that your job duties have increased in complexity and seniority. So it is very important to be prepared to provide that letter from the employer on company letterhead to give enough detail about how this work was actually progressive. On one very important note to remind applicants about the degree requirement is that if you have a foreign degree, which is a non-US degree from a non-US institution, then it is very important actually to get a US equivalency report from an accredited institution that confirms that your foreign degree is actually equivalent to a US degree of the same level. And this can become an issue because in some countries, for example, a bachelor's degree can be obtained in 3 years as opposed to 4 years, which is normally required in the United States. So if there's a mismatch in that regard, there could, be issues down the road. And USCIS does expect to see that US equivalency report for all degrees that are not US degrees. So that is definitely something to keep in mind. Now, the other pathway to qualify for the EB2 threshold is by showing that you have exceptional ability in your field in the sciences, arts, or business. And in order to show exceptional ability, each applicant needs to meet at least 3 out of the 7 criteria that is listed here. So, for example, an academic record showing that you have any degree, even if it's not a bachelor's level or abroad or above, if you have a diploma or certificate from an educational institution relevant to your field, then you may be able to show that instead. 10 years of full-time experience in your occupation. So this would definitely be helpful if you can get detailed letters from previous employers on company letterhead, confirming that you have worked full-time and also what kinds of duties you have performed to confirm that this job experience was in your occupation, an area of exceptional ability. And other types of evidence you can show include a license, membership in professional associations, and generally evidence of recognition that you've received from your peers, government institutions, or professional associations of a significant contribution you have made to the field. Such as awards or, publications, original technologies developed through patents or things like that. So there can be a variety of evidences you can potentially pull from to support this criteria. But in the totality of evidence, the body of the record should tend to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in the field. So USCIS will look at all of the evidences in totality and make that determination. Provided that you have met, at least 3 of these 7 criteria, you'll also need to pass that second step totality evaluation to really be considered that you do have this exceptional ability in the sciences, arts, or business. All right, so once you successfully show that you have met the EB2 threshold, the next step is showing the government that you meet the 3-pronged matter of DANISR test to qualify for an NIW. And the DANISR test is really what sets NIW cases apart from ordinary US company-sponsored EB2 cases, because that is really the default way of getting a green card by getting a company to test the labor market and see if there is any other US person who will take your job and also is minimally qualified to do that job. But if you can show that your case merits an NIW, you get an exemption from this onerous requirement, right? Because testing the labor market takes time, it is costly, and maybe you're not able to get a US company to sponsor you who is willing to take on these extra costs. So getting the NIW approved is basically convincing the government why your case merits this special exemption. So in order to do that, you need to show three criteria, which is set out by what is called the Matter of Dinosaur test. It's a case from 2016 that promulgated these criteria. So the first criteria is that the applicant's proposed endeavor must have substantial merit and national importance. So it is really important in the NIW process is to clearly define your endeavor. And there has been some recent changes to the USCIS policy manual this January, actually, that really clarified that proposing to just work in your field is not an endeavor. So an occupation is not an endeavor. So you can't just say, oh, I'm a cybersecurity specialist and I intend to work for an employer and provide cybersecurity services. That in itself is not going to be considered an endeavor. What the USCIS is looking for is kind of a more specific plan on a project. For example, if you're a cybersecurity researcher and you are developing a new tool on how to use AI to detect fraud, and that is a project that you're developing, they want to see details about that project. So definitely a proposed endeavor is more specific than an occupation. That is a kind of a common misunderstanding that I get a lot from potential clients, but the USCIS does actually expect to see a specific plan on what you're planning to do in your occupation. So another thing to note is that the geographic scope of your endeavor is no longer a concern. So in the Matter of Dinosaur case that came down in 2016, the court moved specifically away from asking what is the geographic scope of your work? Does it touch the entire nation? To what is the prospective impact of your work? And does your work tend to advance best practices for your field as a whole? Or does your work only tend to benefit a local community, such as, your immediate clients who use your services, right? Now, when I say local, it's not referencing the geographic scope of your work. So it is possible, for example, if you're working on a very, very significant economic endeavor that has the potential to revitalize an entire county, or and if you can get government officials to really confirm that the scale of this impact will be of a proportionately large impact compared to the general population of working individuals in that area, that is actually one way you can prove the national importance of your work. But the scale of economic impact in that case does need to be proportionately large. And we have seen in recent developments of NIW adjudications that this pathway is becoming increasingly narrow. So definitely it is a good idea to speak with a very experienced attorney who's current in all of these developments when you're trying to assess the strength of your case, because a lot of it depends on what your proposed endeavor is. All right, so the next step is then to prove that the applicant is well positioned to advance the endeavor. And a lot of things can go into this inquiry. One of the things is, your educational background must be relevant to, your proposed endeavor, professional experience in related and similar endeavors in the past. And really what they're looking for is a track record of success. So one of the things that I also see is that you can propose a very attractive proposed endeavor, but if your previous work history has no relevance to your proposed endeavor, then you will actually get a little bit of a challenge, a pushback. Because when you're proposing a proposed endeavor, it really makes sense if it's, kind of tightly tied to what you have been doing in the past to really show that you have a track record of success already in similar and related projects. So what we like to do frequently, especially for clients in the industry, are really to collect a portfolio of past projects that they have done. And in those, collection of past project evidence, you can use things like, any media articles that discuss the impact of this project, any intellectual property that, resulted from this project, such as patents or publications that came out of it, or if the results have been shared with other industry experts through, industry newsletters or trade publications or things like that. All of these evidences of impact can be very helpful when you're building up this portfolio of past projects, which is quite critical in defending your claim for well position. And another thing to note is how far along is the endeavor. So if you are building a startup, have you already made the LLC or the incorporated an entity? Have you received funding for your startup project? Have you gained admission to prestigious accelerators for your business project? All of these things also can be relevant in the government deciding whether you're well positioned to bring forward this project. And the further along your endeavor is, you may have a better chance of convincing the government that this is really going on and that this endeavor will likely be successful. So in the case of entrepreneurs, having had, venture capital support and things like that could definitely be helpful, or even letters of intent from clients or potential partners in the United States who can show that they are interested in working with you in that particular project. That can also help in providing good optics for convincing the government that your project is actually valuable and has the potential to impact the field more broadly, really, than just providing a small benefit to your immediate clients. All right. So the third and last prong of the matter of dinosaur test is that the applicant must make a showing that on balance it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification in that particular project. And here you can argue this prong in a multiple ways, and it's kind of more of a balancing test, right? So if you're someone who has, really shown that you have an exceptional or extraordinary ability in your field and have participated in, prestigious judging competitions, or if you've been mentioned in the media or things like that, evidences that you would typically use in an EB1A petition, you can also use them here and say, looking at this outsized impact that you have had in the field, it will definitely, outweigh the ordinary benefits of replacing you with, a US professional with minimum credentials. You can also point to evidence from prong 1 and 2. So, for example, if the expected benefit of your work in the United States towards serving US interests is much greater than, just protecting the US labor market for one additional person. So, for example, if you are actively developing a new technology that can transform the industry in a broader way, certainly those kinds of broad, substantial benefits would naturally outweigh the ordinary benefits of, protecting the US labor supply for, one other person than you. And for entrepreneur petitions, we often rely on the fact that entrepreneurs tend to create jobs in the United States, and some entrepreneurs tend to create a high number of jobs. And if you compare that with the Congress's policy of protecting the U.S. labor supply, if you have an entrepreneur who's coming in and creating dozens and dozens of new jobs, then Congress's policy in that case will be better served by exempting the entrepreneur from this requirement, such that more jobs can be created and benefit the U.S. labor supply. So that is definitely a common argument that we use in entrepreneur cases. And another thing to note, which can be positive to entrepreneurs, is that the NSR specifically notes that entrepreneurial work can lead to an NIW, and also notes that the planned venture does not need to ultimately succeed, as long as the applicant can show that it is plausible that it can succeed. All right, so then let's shift gears a little bit and talk a little bit about some timing and other strategic considerations while that is relevant to your decision when you're going forward with an NIW petition. So let's talk first about timing consideration. Now, how long does it take to get an NIW approved, and how long does it take for you to actually get the green card? Now, one positive change from I think around 2022, I believe, is that premium processing is now available for NIW applications. Now, when we say NIW applications, we're referring to the initial I-140 petition. So there are two steps to applying for a green card. The first step is the initial I-140 petition to establish your eligibility for the green card. And once that is approved, you can go forward to step 2 of the green card application, which is the actual green card application. You will either apply for adjustment of status to the green card holder, an I-485, if you're already in the United States on a different status, or you can also process this through your home country consulate through what is called consular processing for an immigrant visa by filing a DS-260. And if you've never been to the United States and you're only in, your foreign country, that would really be the only option to use to, get that immigrant visa so that you can make the initial landing as a permanent resident. So in the step 2 of the process, you have these two options. Now, when we're thinking about the timing, the first step, the underlying I-140 premium processing is indeed available. So if you pay extra for the premium processing, you can get an action from the USCIS. It can be an approval, it can be a request for evidence, it can be notice of intent to deny, but USCIS pledges to get back to you within 45 business days. And they would typically actually take the full length of this time now. It used to be a lot quicker in 2023 and even in the beginning of 2024, but recently we've been seeing a slowdown in premium processing cases. So we tend to see that the USCIS is actually taking the full length time to get back to you if you pay premium processing. Now, if you use regular processing, this underlying I-140 will take about a year to process. So that means the petition will be pending for a year for the initial I-140 part. And once you have the approval, you will also need to check if your priority dates are current, and then you can move on to step 2 of the process, which is to either apply for an I-485 or to apply for an immigrant visa through your home country consulate. Now, so the thing about premium processing is that even if you use premium processing and get the I-140 approved early, you may still to wait a little bit until your priority dates are current because ever since the end of 2022, we've been seeing such an increase in people who are the number of people who are being approved for the green card under this category, the EB2, as opposed to compared to how many immigrant visas are available each year. So what that means is that it creates a backlog because of this mismatch between the number of visas available in this category and the number of people who are approved and eligible and applying for such green cards. So right now, I would say on average, you can expect somewhere between 1 year to 1.5 years of this backlog where you will need to wait basically after you file your NIW and you have the approval. You will still need to wait until your priority dates are current, basically when you reach the front of the line, so to speak, and you can actually move on to, step 2 of the process by filing an I-485 or filing for an immigrant visa. So definitely when you're thinking about the entire timeline, it is important to be realistic, and if you want to discuss about this timing consideration a little further, feel free to set up a consultation with one of our experienced lawyers, and we'll help you walk through the inquiry. And obviously, also the waiting time for a priority date depends on your country of birth as well. So a lot of considerations that go in there. So definitely keep that in mind. Now, let's move on and talk about another consideration, which is your underlying visa status. So filing for a national interest waiver petition, filing the I-140 is, in effect, kind of it can be considered an expression of immigrant intent. So you are interested in a green card in the future. It's not the strongest type of immigrant intent you can express, but it is still it can still be considered an intent regardless, right? And this risk really is amplified if you're on non-immigrant visa statuses that does not allow for dual intent. So an easy example is the TN visa, which is scrutinized for non-immigrant intent quite strictly. So once you file an I-140, which is a petition for immigration, right? An immigrant worker petition. After you have that filed, the next time you need to go through the border and, renew your TN visa, you may actually, receive some extra questioning from the border officer related to that. And that may give you some trouble when you're trying to make that application. So one strategy that you may choose is to go ahead and renew your TN visa first for another 3 years, and then once you're in the United States, then maybe you can take other actions such as applying for an I-140. So the timing of filing an immigrant petition may have such strategic considerations. Um, another um, another strategy you can take is you may also file the immigrant visa petition using consular processing, which means that you provide the representation to the government that you will leave the United States when you're done with your non-immigrant visa and actually attend a consular interview abroad, which also is a different way to, give a representation that you don't intend to adjust status in the United States. So there can be a variety of strategies you can take. Definitely speak to your lawyer if you are wading through these options. So let's talk a little bit about the application process. So as I mentioned before, it is a two-step process to apply for a green card. The first step is to submit the form I-140 with the proof that you meet the EB2 qualifications and also proof that you meet the three-prong matter of NANSR criteria to merit an NIW. And only if there is an immigrant visa available in your category, you may be able to concurrently file an I-485 green card petition with the I-140. This, to the current, this is not available for EB2s. Up till now, because there is this priority date backlog that I've been discussing to you about. And it has been this case since late 2022. And we don't really know when the priority dates will become current again for this category. But it is definitely worth keeping an eye on the recent developments and see if the situation improves in the future. And as I mentioned earlier, you may also file the I-140 and choose to go to your home country consulate to attend the immigrant visa and do the landing that way. That is always an option if you are in the United States in a different status. Pros and cons. That's the last topic that I will go over before moving on. Pros and cons of adjusting status in the United States versus consular processing. So one thing to note about adjusting status in the United States, and this refers to the I-485 process that I've been talking about. One thing to note is that after you file the I-485, there may be a period where you're basically stuck in the United States a little bit because you can't travel abroad while your I-485 is pending if you don't have a what is called an advanced travel authorization. So if you have the advanced parole, then you can travel abroad and then come back in and be, paroled in again while your I-485 is pending. But if you don't have that, if you travel abroad, that will mean you are abandoning your I-485 application to adjust your status. So that is definitely one disadvantage of filing for an I-485. Now, so the advantage of consular processing is that you retain the ability to, travel back and forth internationally if that is a priority to you. Now, the advantage of adjusting status in the United States is that it gives kind of a continuing ability for you to continue staying in the United States while your I-485 petition is processing. By contrast, if you process the green card through consular processing, you don't get independent status, well, authorization to continue staying in the United States while your green card is processing. So there is a possibility you may be stuck in, in your home country for, some period of time, depending on how long it takes to consular process. And different consulates do have different um, what do you call it, availability of, visa appointments. So it may actually be of benefit for you if your home country consulate is one of these very busy consulates. Maybe it may benefit you to opt for adjusting status, because then you only deal with USCIS, which is one agency and has a little bit more predictability with that. So there definitely can be various pros and cons to adjusting status versus consular processing. If you apply for an adjustment of status with I-485, you also get the ability to apply for EAD, an employment authorization card, that allows you to, be working for any employer while you wait for the adjudication on your I-485. So that can be quite a specific advantage for some people. So definitely speak to your lawyer if you're trying to choose between the two options. We'll be happy to guide you on, what can work best for your circumstances. All right. So now let's talk a little bit about some updates in the USCIS guidelines on how they look at STEM and entrepreneur cases. Now, these guidelines are still there at this moment. Now, we don't know if those policies would change in the future, but we are definitely keeping an eye on recent developments. And there has been a slate of new changes in January 2025. They did not remove those STEM and entrepreneur guidelines, although they made some clarifications on certain parts here and there. So definitely we are very well monitoring the developments in that regard. Now, with regards to the STEM specific guidelines, what happened in 2022 was the government added some explanation on what can be counted as an endeavor of national importance. And if a STEM individual is working on an endeavor that is related to advancing critical and emerging technologies, there is some phrases in the policy manual that says this is, positive for finding a national importance. And in those policy language updates, they clarify that research and development is not solely limited to academic settings. Even if you're doing R&D in industry settings, as long as you can show prospective broad impact of this new development, you will be, you could gain some favor in meeting the national importance criteria here. STEM advanced degree holders, if you have a US degree, a master's degree in STEM, or a PhD degree in STEM, that can definitely be a favorable element for well-positioned. But they do say quite specifically that well-positioned cannot just be met through one degree. You do need to have a little bit more than just the degree to meet the well-positioned threshold. So that is a caveat to highlight here. Let's talk a little bit about entrepreneur-specific guidelines. So the government added some discussion about entrepreneur cases and how entrepreneurs can rely on some non-traditional types of evidences. For example, an entrepreneur in industry may not always be publishing journal articles in traditional academic journals, or having citations of their papers, or, publishing patents under their own name. So there are some other alternative types of evidences that entrepreneurs can rely on to nevertheless express the merit of their endeavor, the importance of their endeavor, and how they're well positioned to advance this endeavor. So things like, significant media attention on the petitioner or the business that they are starting up, awards or grants received from government entities or other entities, letters from third-party industry actors such as venture capital firms, letters from government agencies, and evidence of revenue generation and significant growth can all be helpful towards supporting substantial merit and national importance. And for well positioned, you can provide evidence that you have a ownership and a critical role in the U.S. entity, evidence of interest from investors in your US project, receipt of any grants or awards, as mentioned above, publication of intellectual property by the company, not necessarily by the individual. So patents held by the company can actually also be used in support of this prong. Even if you're not listed as an individual investor. Media attention is always a good plus for any of these prongs, and letters from third parties, even if they're not academics, if they are, if they're considered somewhat objective in their fields, such as venture capital experts who regularly review, a lot of businesses and provide opinions on them and their prospective impact. Those letters can always be helpful in meeting those prongs. And letters that describe your past work in the field and how that has been impactful as well can be helpful towards meeting the well-positioned prong. All right. So now then, let's talk a little bit about what an NIW submission looks like in practice, and talk a little bit about the documentary elements that, is typically included in an NIW submission. So the first thing to note is to ensure that you provide proof that you meet the EB2 threshold requirement. And as I mentioned in some of the earlier slides, you can meet the EB2 threshold in two ways, either by showing that you have an advanced degree defined as a master's degree or above, or by showing that you have exceptional ability by showing 3 out of the 7 criteria of evidence that tends to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered. So if you are meeting the threshold through an advanced degree, you will typically include the copy of the diploma, the transcript showing your coursework. And if you are meeting this threshold through a bachelor's degree and 5 years of progressive work experience following your bachelor's degree, then you will not only include your copy of your bachelor's degree with a diploma or transcript or otherwise, but also include the letters from previous employers confirming that you have had that full-time experience for 5 years, and also that your job duties have changed to include more complex and senior duties as time went on. So you will include both these proofs in your petition to prove that you meet the advanced degree threshold. Now, one thing to note is that the work experience and the degree must be related to each other. And this is a new development that the USCIS has clarified in its most recent updates, policy manual updates in January 2025. And the degree must be related, the experience must be related, and also all of these things must also be related to your proposed endeavor. So one of the things is that one of the examples that the new policy manual talks about is that if you have a computer science degree and if you have a computer science work experience, and then you propose that you will come into the United States to be a baker, and they're saying, oh no, that's not going to work because it's just not related to the proposed endeavor. So definitely ensure that everything is lining up when you're trying to meet the threshold requirement. It is definitely becoming more and more important in NIW adjudications. Now, for exceptional ability, if you're meeting the threshold through that, ensure to provide the 3 out of 7 evidences, category of evidences that tend to prove that you are actually operating at a level that is above what is ordinarily encountered, and ensure that the area of exceptional ability that you're proving here is indeed related to your proposed endeavor. Now, the other part of an NIW submission is evidence that you qualify for the national interest waiver through the 3-pronged matter of Denisar test that I've mentioned before, which is substantial merit and national importance, well-positioned, and on balance, beneficial to the United States to exempt the labor certification for that particular case. So this can include things like, background information about your particular project and why it's important, which can include government reports. Now, It is very important, though, to make sure that the articles that you include are very tailored to your particular project. So, for example, if you are, you know, um, proposing that you will develop a new technology within the semiconductor industry, and then you pair that with a general, very general article talking about the importance of the whole semiconductor industry to the country as a whole, then the government may struggle to connect that article to the actual importance of your specific project, which is focused on the particular technology that you are developing. So, the more specific the support is regarding the importance of your work, the better it is for your case. And the government does tend to publish many RFEs challenging the relevance of articles that speak very generally about the industry of a labor shortage or things like that, and say that they are not relevant to, you know, describing the importance of an applicant's potential, proposed specific project in the United States. So that is an area that requires quite careful attention when you're preparing your petition. Let's talk a little bit about expert letters. Expert letters can be a very powerful tool because they they can, really delve deep into the applicant's particular project and discuss the background of why this is needed, and also describe the potential prospective impact that this work can have. Through the voice of an expert in the field, which gives more credibility. So it is important to really be careful about who you're asking a letter from. So if you can get a letter from a relevant government agency covering the field, that can be a very powerful addition to your case. You can also get expert letters from independent experts in your field who can describe either your past achievements or the expected impact of your future work. And that can be very specific to your particular project and can be very helpful in meeting the prongs of matter of Dinosaur. Resume, degrees, proof of professional accomplishments, and data about an applicant's past record of success is always helpful in meeting the second prong, well positioned to advance the endeavor. As I mentioned before, it is a good idea to provide a kind of a portfolio of what you have done in the past to support the claim that you are well positioned to continue doing that work and producing an impact in your field in the future. And finally, for entrepreneurs, some type of evidences that could be helpful to include contracts with major industry players that could describe significant interest from the industry in your work and also show progress in your proposed endeavor, letters of intent from prospective clients or business partners, or even government agencies that propose to work with you and express interest in your specific project can definitely be helpful. And finally, if you have received capital funding, investment from venture capital firms or otherwise, you can show that to show that you have support to bring forward your business project to ultimate success. All right. So now then for the last topic, let's discuss a case study, an example case study of a successful NIW case, which actually was approved on appeal at the AAO. So what happened was the AAO flipped the original denial at the USCIS and actually found that this person merited a national interest waiver. So let's start by describing what the endeavor was. So in this case, the applicant was an entrepreneur who formed a small consulting firm focused on improving services to U.S. veterans. And in support of substantial merit and national importance, the applicant submitted a variety of very targeted evidence. So, expert letters from very senior officials in U.S. philanthropic and government organizations discussing the difficulties currently faced by returning veterans from Iraq and Afghanistan, describing what are the limitations of existing approaches to help them reintegrate to society, and importantly, describing the prospective impact of the applicant's own project to organize very targeted programs to help reintegration of these veterans. So Not only did these letters describe the limitation and gap in the industry, the letters also described how specifically the applicant can come and change that and why it was important to do that. So those types of evidences were very helpful in proving substantial merit and national importance. So well positioned to advance proposed endeavor. So to do that, one of the things that the applicant did was to provide targeted expert letters from government officials, businesses, and philanthropy organizations that he's worked in the past. So these evidences really started to build a picture of what this person has been doing in his home country that was directly related to what he was planning to do in the United States, and importantly described the impact that these projects already had in the UK, which was where the applicant was from, on actually succeeding to successfully create, hundreds of jobs for U.S. veterans, and also helping them reintegrate successfully to society, and really helping improve the welfare of veterans. And these types of testimonials from leading associations in the field in his home country actually was very helpful in proving the second prong well positioned. For the third prong, on balance, to prove that it was beneficial to the United States to waive the requirement of a job offer and labor certification, what this application did was to highlight the fact that this person was an entrepreneur and it would be impractical for the applicant to obtain a labor certification. So really, the NIW was the only option for this person to gain permanent residency to continue to do this very impactful work. But more importantly, the application was able to highlight the broad systemic benefits that the project can have in improving best practices in, veterans welfare, and also really was able to highlight the public interest benefits that would result broad benefits to society by improving the welfare of veterans and significantly advancing the government's priorities there, in a way that was different and distinct from ordinary existing approaches. So that was definitely key to a successful case here.
Great. Thank you very much, Jiyae. A lot of wonderful information. So we do have two questions that have come in, and while Jiyae is answering those, I encourage anyone else who has a question to please send it in through the question and answer box or the chat box, whatever you prefer. So Jiyae, the first question, for startup founders, are there any guidelines on what ownership share the beneficiary should have in the company? Do they need to own a certain percentage of the company?
So really, there is no minimum requirement for that. So what they're saying is if you own a majority stake, then it could be helpful in the third prong, saying that, you can't avail yourself of the, traditional pathways of labor certification. So that gives them just another, argumentative point to make when we're arguing the third prong. But otherwise, even if you're a startup founder and you don't own anything in the company, if you are actually going to play a critical role in the company, nevertheless, you can still say that. And that can actually also be helpful for proving well positioned. And a critical role can definitely help with that aspect. So no, there is no minimum ownership requirement of the U.S. entity. It is just listed as one of the factors that could work towards meeting some of the prongs. You can really meet the matter of Denizer prongs in any combination of those helpful evidences.
Perfect. And this next question I really like because I think it's relevant to a lot of people. The NIW, obviously, Jiyae, as you talked
Mm-hmm.
about, you can apply based on a business plan. But if someone wants to start taking steps to make the business operational, like setting up the LLC, opening a bank account, things like that, starting to pursue the endeavor, let's say they're here in H-1B status. If they're in the US in a status like H-1B where their work authorization's limited, what guidance do you give in terms of how whether they can take steps toward pursuing the endeavor and how far they can go?
So you need to be very careful if you are in the United States in a different status, because you don't want to wade into the territory of unauthorized work, even if you're not getting remuneration from your startup. If you are actually doing productive work for the company, then there is always a risk to for a potential unauthorized work finding, because when you're on H-1B status, you're only allowed to work for your H-1B employer. You can't really be doing side hustles. Without having the requisite work authorization. Definitely schedule a consultation with us so that we can maybe discuss some of the other options that may be available to you. So, for example, on O1 visa, you may be able to work for multiple employers on O1 visa through using an agent relationship. So definitely, this is a question that would benefit from a consultation, so that we can look at what are the other options that may be available to you. But to answer your question, there is a tension between how much you can develop your, entrepreneurial endeavor and how much you're allowed to do in your current status. So a balancing act should definitely be advised here. And if depending on your circumstances, it may be, a good idea to not have the proposed endeavor develop so much to, open up these risks for unauthorized work findings. So this definitely would benefit from a lawyer's expert advice.
And Jiyae, you mentioned that an O1 might allow you to use the agent relationship.
Correct.
The follow-up question on this is it possible to do a concurrent H-1B for your own startup?
That definitely is a complex question. We need to talk a little bit about the ownership structure that you propose to use in your startup. So, yeah, that is a question that I would reserve for a consultation for sure.
Yeah, and what I'd add to that is we do file NIW applications based on a business plan. So it is not a requirement that the person be already pursuing the endeavor, although that does help the application. It's
For
not an
sure.
absolute requirement. So if you find yourself in a situation in the US where you're potentially risking your status in order to get the endeavor going, it might be worth considering. Having a robust business plan, maybe an economic report, something like that to reinforce the application. But I think what Jiyae said is absolutely right. As consultation is the right place to discuss that further.
Definitely.
So in terms of the EB2 petition price, I'm going to split that into legal fees and then fees that go to the government. So legal fees, you can reach out to us, schedule a consultation. We're happy to share details on our pricing. Jiyae, do you want to talk about what the government charges in terms of the filing fees with and without premium processing?
Sure. Let me actually look that up real quick.
Sure. And while you're doing that, I can actually, why don't I look that up while we're talking about the next question? So
Okay.
you mentioned for a TN status, filing an NIW might have problems since you're showing that you've applied for the green card while you have TN status. After filing the I-140, would you have trouble re-entering the US if you take a short trip to Canada, assuming you're on something like a TN?
Right. So, for that one, we do want to distinguish the context of applying for a renewal of your TN visa versus having a TN visa for 3 years and um, traveling abroad and re-entering on the existing TN visa. So, in the context of having a TN visa granted for 3 years and then going abroad and entering on that existing visa, you may be okay with, even if you have the I-140 filed. But what I was discussing earlier was in the context of actually applying for a new TN visa based on a new or an extended employment relationship, then the entire, your eligibility will become, under scrutiny again, and that's when the I-140 could come into play as a challenge.
Right. And so to follow up on the petition fee, so premium processing is going to cost $2,805. And again, premium processing is an option to expedite the application. If you don't choose premium processing, as GA said, you could be looking at about a year before your I-140 is decided. And then the I-140 filing fee is $715 for the petition itself. And then you do need to pay an asylum program fee, which if you're a small employer, so I believe that's under 25 employees, that is an additional $300. So you're looking at about $1,000 for the I-140 and an additional $2,800 if you want to expedite that application. All right. Well, thank you all for the great questions. Jiyae, thank you for the wonderful information. We do hope to see you all on future webinars. Keep an eye out for our email. And if you have any questions in the meantime, don't hesitate to set up a consultation. We'd love to talk with you. In the meantime, stay well and have a great day. Thank you.
Thank you.